You said earlier that the use of techniques that are basically designed for restraining adults is not appropriate when dealing with young people in the secure state. I think some staff would say, well, but if you look at some of the youngsters in the secure state, they're as big and as strong as adults and physically very energetic. Would you like to make a comment on that proposition? Does it change your view in any way?
No, it doesn't change my view. I fully accept that some of the children and young adults in the estate can be very difficult to handle. I accept that. But with the range or this basket of techniques that I've been talking about, there should be graded responses. From a very simple response to something that would deal with something of a much greater severity in terms of the violence that the members of the staff or other children are facing. But it doesn't change my view at all just because of the size of them. That's a whole basis of being able to design and devise strategies and techniques that will work. And my other point is that although many of these techniques, and we saw some examples earlier on today, where one member of staff rushes for the head, two members of staff then rush for the arms, and they drag the person down. That's a technique that has come directly from the prison service. But even in the prison service, when we're talking about adults, the use of force is frequently misused. And use of pain, even in those circumstances, in many cases, can't be justified. But of course here we're talking about children and young adults. But a whole series of techniques can be designed that could effectively deal with the problems of violence and aggression across the estate in a graded and sensible way.
Has the SDGB or any similar organisation, I don't know myself how many similar organisations there are, ever been asked to devise specific techniques for young people for use by government agencies and in the public sector?
No. I've certainly been asked, and frequently, several times in the last month, for example, to comment on techniques and to assist various organisations from statutory bodies through to the private sector in helping to amend or to devise techniques, or could I suggest different ways of dealing with this situation or that situation. But as far as I'm aware, it's the prison service that is central and instrumental in designing the techniques that are being used in or across the youth estate.
Is there any shortage of independent outside expertise that could help prison service or the Youth Justice Board to devise techniques specific to young people?
I don't think there's a huge number of people who could do it, but there are certainly people there who could do it. I think the difficulty is the ownership of it, and certainly my understanding from working with the Prison Officers Association and the Prison Service is that they go on very, very closely their techniques as being something very, very important to them that they keep secret and they keep for their own.
Yes, you obviously have a great deal of experience of self-defense and martial arts as sport, in which those who participate, by definition, are volunteers. So they're involved for the purpose of the sport, presumably, not for the purpose of the violence.
Yes.
And you would probably reject participants who you thought were merely there for the violence that is a part of the sport. Would that be fair?
Yes.
Yeah. To what extent do you think that the use of violence by means of restraint is seen by young people as either a badge of office or as something they would wish to bring upon themselves for other reasons?
Yeah, I think that is a problem. But it's a problem that the staff can deal with and ought to deal with by not engaging on that level with the young children.
Yes. Do you think that there is sufficient understanding of de-escalation techniques to enable patient and properly trained staff to avoid the use of violence when it's being provoked?
You know, I've seen some excellent examples of de-escalation strategies.
Can you give us a couple of examples?
Oh, well, yes, certainly. Firstly, one of the best examples would be that any use of physical intervention will be seen as a breakdown of the de-escalation process. So, not really by way of blaming members of staff, but it has to be recognised, and this is right across a number of sectors, that certain members of staff will use restraints more often than others. Others will be able to deal with very similar situations without having to lay the hand on the child at all. So the de-escalation techniques are really important. And really that talking strategy, why do you want to do that? Do we need to get involved with physical intervention? Do we need to restrain you? Is there a problem that I can help you with? All of these things and many, many more. I think there are some good examples, but I don't think there are enough good examples of good practice. And not only that, as I indicated before, de-escalation strategies must be seen as ongoing. So even if they failed initially, they should be continuous throughout even a period of restraint, with the aim of curtailing it or bringing it to an end as quickly as possible.
You're a lawyer as well as an expert in these strategies. Is it your view that there is sufficient understanding among those who run secure establishments of the legal implications of improper or unauthorised use of restraint? And combined with that, a question as to whether you think that the authorities provide sufficient access for young people who may have legitimate legal grievances.
I'm not sure about the organisations, whether they understand. I mean, I would hope that they would. Certainly the staff members, so those people who have to deal on a regular basis with the children and young adults, there's a lot of confusion there. What they're permitted to do, what they're not permitted to do, they're getting so many conflicting bits of advice and information, both from training courses and from their institutions. So I think that it is important that they realise that a lot of the things that they are doing and may see their peers do are potentially unlawful and can give rise to both criminal and civil liability. I think that's really a pity.
Well, thank you very, very much indeed. You've provided us with a very interesting session, when I say so, and brought a perspective one doesn't often hear at such meetings to bear upon it. So we're very grateful to you. Thank you.